Hello, dear friends. Now we'll start the third lecture on Erasmus Ecclesiastical Law. We're explaining the general comment number 22 on of the Human Rights Committee on Religious Freedom. And now we explaining the fourth paragraph, which contains the substantive rights of freedom of religious or non-religious manifestation. The freedom to manifest religion or belief contains indicatively in its formulating four ways of manifestation, that is, worship, observance, practice, and teaching. This list of different forms of manifestation is only indicative, this list, because there are also other forms not enumerated expressly in the religious manifestation. And the general comment number 22 says that these forms, the express forms of religious or religious manifestation, these four forms, indicatively enumerated, are to be construed broadly. Then it gives the meaning of those forms of manifestation. Worship. Worship concerns ritual and ceremonial acts, giving a direct expression to belief. Second, worship means various practices integral to such acts, including, among others, the building of places of worship, the use of ritual formulae and objects, the display of religious or non-religious symbols, and the observance of holy days and days of rest. The meaning of observance and practice of religion or belief contains also ceremonial acts. It contains also customs as the observance of dietary regulations, the wearing of distinctive clothing and head coverings, participation in rituals associated with certain stages of life, and the use of particular language customarily spoken by a group. The terms practice and teaching includes acts integral to the contact by religious groups of their basic affairs, such as freedom to choose their religious leaders, priests, and teachers, the freedom of establish seminaries or religious schools, and the freedom to prepare and distribute religious texts or publications. In the fifth paragraph of the general comment, the Committee on Human Rights of the United Nations say that the freedom to have or to adopt a religion or belief necessarily entails the freedom to choose a religion or belief, including inter alia the right to replace one's current religion or belief with another or to adopt atheistic views, as well as the right to retain one's religion or belief. Article 18, paragraph 2 bars coercions that would impair the right to have or adopt a religion or belief, including the use of threat or physical force or penal sanctions to compel believers or non-believers to adhere to their religious beliefs and congregations, to recant their religion or belief, or to convert. Policies or practices having the same intention or effect, such as, for example, those restricting access to education, medical care, employment, or the rights guaranteed by Article 25 and other provisions of the Covenant, are similarly inconsistent with Article 18, paragraph 2. The same protection is enjoyed by holders of all beliefs of a non-religious nature. In the 5th paragraph, the committee speaks about the meaning of the terms to have or to adopt a religion or belief, which are religious rights belonging to the first subgroup of religious rights under the name freedom of religious or non-religious conscience. Freedom to have means freedom to retain one's religion or belief. Freedom to adopt means freedom to change religion or belief. And this term adopt means to change, because the redactors of in the National Covenant on Civil and Political Rights prefer to use the term to adopt instead of writing to change, in order to facilitate the adoption of the International Covenant on Civil and Political Rights by Muslim countries, because as it is known, in Muslim countries, only the right to change, to convert to Islam is accepted, and not the right to convert from Islam to any other religion is permitted. Then, in the same paragraph of general comment, the Human Rights Committee explains the paragraph 2 of the Article 18, which forbids, bars, coercions that would impair the right to have or adopt a religion or belief. Such coercions could be the use of threat, of physical force, or penal sanctions to compel believers or non-believers to adhere to their religious beliefs and congregations. There are also other types of coercions prohibited by the Article 18, paragraph 2nd of the International Covenant, which have the same intention or effect. That is, practices or policies which connect access to education, medical care, employment, to retain a religion or to change a religion to another one. Now we go to the sixth paragraph of the General Comment number 22. In the sixth paragraph, the committee says that the Article 18, paragraph 4 permits public school instruction in subjects such as the general history of religions and ethics, if it is given in a neutral and objective way. The liberty of parents or legal guardians to ensure that their children receive a religious and moral education in conformity with their own convictions set forth in the Article 18, paragraph 4, is related to the guarantees of the freedom to teach religious belief started in Article 18, paragraph 1. The committee notes that public education that includes instruction in a particular religion or belief is inconsistent with Article 18, paragraph 4, unless provision is made for non-discriminatory exceptions or alternatives that would accommodate the wishes of parents and guardians. In the sixth paragraph, the committee explains the rights of parents or legal guardians to ensure that their children receive a religious and moral education in public schools in conformity with their own convictions. This right of parents or legal guardians concerns is related to the content of religious instruction in public schools. If a religious instruction is given in a neutral and objective way, that is, if the religious instruction is a general history of religion and ethics without any indoctrination, then an exemption from this religious instruction is not permitted. But if a religious instruction in a particular religion or belief is given in public schools, then the state must provide for exemptions according to the wishes of parents and guardians, because religious education in public schools, which constitutes an indoctrination in a particular religious belief, is not consistent with the right of parents or legal guardians to ensure that their children receive a religious and moral education in conformity with their own convictions, it becomes consistent only if it is given only if the law, state law, provides for non-discriminatory exemptions or alternatives that would accommodate the wishes of parents and guardians. In the 8th paragraph, the Committee on Human Rights explains the limitation clause contained in the 3rd paragraph of the Article 18 of the International Covenant on Civil and Political Rights. Article 18, paragraph 3 permits restrictions on the freedom to manifest religion or belief only if limitations are prescribed by law and are necessary to protect public safety, order, health or morals, or the fundamental rights and freedoms of others. The freedom from coercion to have or to adopt religion or belief, and the liberty of the parents and guardian to ensure religious and moral education cannot be restricted. In interpreting the scope of permissible limitation clauses, state parties should proceed from the need to protect the rights guaranteed under the Covenant, including the right to equality and non-discrimination, on all grounds specified in Articles 2, 3, and 26. Limitations imposed must be established by law. It must not be applied in a manner that would vitiate the rights guaranteed in Article 18. The committee observes that paragraph 3 of the Article 18 is to be strictly interpreted. Restrictions are not allowed on grounds not specified there, even if they would be allowed as restrictions to other rights protected in the Covenant, such as national security. Limitation may be applied only for those purposes for which they were prescribed. They must be directly related and proportionate to the specific need on which they are predicated. Restrictions may not be imposed for discriminatory purposes or applied in discriminatory manner. The committee observes that the concept of morals derives from many social, philosophical, and religious traditions. Consequently, limitations on the freedom to manifest religion or belief for the purpose of protecting morals must be based on principles not deriving exclusively from a single tradition. Persons already subject to certain legitimate constraints, such as prisoners, continue to enjoy the right to manifest their religion or belief to the full extent compatible with the specific nature of the constraint. States parties report should be provided information on the full scope and effects of limitations under Article 18, paragraph 3, both as a matter of law and their application to specific circumstances. As concerns the limitation clause, Human Rights Committee explains that a test is provided for controlling the legitimacy of a limitation imposed on any religious rights belonging to the second subgroup under the name freedom of manifestation of religion or belief. The test based on the limitation clause is composed of 3 stages. First stage, the limitation is provided by the law, substantial or formal. Formal means a law of parliament. Substantial means a regulation enacted by the administration under a power of attorney given by a formal law, and in the context of this power of attorney given to the special administrative authority. Second stage, the limitation imposed by any power of the state authority, that is legislative, administrative, or judicial power, must aim one or more of the exhaustively enumerated purposes, that is, forms of public interest provided in the limitation clause, that is, public safety, public order, public health, public morals, fundamental rights and freedoms of others. No any other form of public interest, no any other purpose is permitted for a legitimate imposition, limitation on religious manifestation. Any other purposes which are used as in the limitation clauses of other human rights are not permissible for any limitations on religious manifestation. For example, a permissible purpose for religious manifestation is public safety. But national safety is not permitted for religious manifestation as it is permitted in limitation clauses of other human rights. The third stage of the test of controlling the legitimate or non-legitimate imposition of a limitation on religious the proportionality principle. That is, if the state's limitation of religious manifestation for an aim provided by the limitation clause is necessary or not. The difference of the limitation clause between the European Convention on Human Rights, Article 9, paragraph 2, and the Article 18, paragraph 3 of the International Covenant on Civil and Political Rights is that the European Convention provides for the limitation must be necessary in a democratic society. But this phrase in a democratic society is not found in the limitation clause of the International Covenant on Civil and Political Rights, because not all the states of the world are democratic one. The 8th paragraph of the general comment gives some explanations necessary for legitimacy of state limitation on religious manifestation. Limitation imposed must not be applied in a manner that would vitiate the religious rights guaranteed in the Article 18. First explanation. Second explanation. The limitation clause must be strictly interpreted. That is, restrictions are not allowed on grounds not specified there, even if they would be allowed as restrictions to other rights protected in the Covenant. As I have said already. Third explanation. Limitations may be applied only for those purposes for which they were prescribed, and must be directly related to the specific need on which they are predicated. Third explanation. Restriction may not be imposed for discriminatory purposes or applied in discriminatory manner. Then the committee explains public morals, saying that limitations on the freedom to manifest religious beliefs for protecting morals must be based on principle not deriving exclusively from a single tradition, but this moral principle must derive from many social, philosophical, and religious traditions. Then, in the paragraph 9 of general comment number 22, the committee says that the fact that religion is recognized as a state religion or that it is established as official or traditional, or that its followers comprise the majority of the population, shall not result in any impairment of the enjoyment of any of the rights under the covenant, including Articles 18 and 27, nor in any discrimination against adherents of other religions or non-believers. That is, a state religion, or an official religion, or a traditional religion, is in conformity with religious liberty and equality if it does not discriminate against the other religions. Now we finish our third lecture on Erasmus Ecclesiastical Law. Thank you for your attention.